Nearly 250,000 private renters fear eviction over arrears, according to the debt counselling charity StepChange. If you've ended up being behind on your rent and your landlord is threatening court action, what should you do? I'm Daniel Barnett, a barrister based in central London, and I'm also the presenter of the Legal Hour on LBC Radio. In this video, I'll explain how you could avoid going to court, the eviction process, and what to do before attending your court hearing. But first of all, please subscribe to this channel and turn on notifications for my latest Legal Explainer videos. Even if your landlord has already started court proceedings, you still might be able to resolve the issue. Contact them as soon as you can to suggest a repayment plan. Explain why you're struggling to pay your arrears and how you intend to pay them back. Make your arrangement realistic, because if you fail to stick with it, most landlords won't give you another chance. In an ideal world, write up the agreement, add your signature, and get your landlord to sign it also. But in the real world, an email chain showing the agreement is good enough. Keep a copy of all correspondence between you. That's really important. Now, you can use the links in the show notes below to see whether you're eligible for government help, such as housing benefit, universal credit, or a breathing space. A breathing space is a period of time when the eviction process must be halted. Use it to talk to an advisor and work out your options. If your landlord rejects your payments, save that money, because it will help the court see that you're trying to pay back your arrears, and you can use it towards any payment that the judge might order. Now, your landlord can't just throw you out onto the street. Where you owe rent, they'll usually give you what's called a Section 8 notice with 14 days to leave, and then they'll get a court order to enforce it. You're entitled to more protection if you have something called a secure tenancy. Again, use the link in the show notes to work out what type of tenancy you have. If your landlord doesn't follow the proper procedure, or if your landlord harasses you by trying to force you out your home without a court order, they're breaking the law. Once you're given notice, it's usually best to stay in the property, because otherwise you could be classed as intentionally homeless and your local authority might not rehouse you. Check the details on the notice are accurate. When the notice period has ended, your landlord can go to court to get a possession order to evict you. When that happens, the court will send you a defence form. Send that back within 14 days and include relevant details such as any errors you think your landlord has made in the notice, the reason you can't pay your arrears, and any benefits you're owed or other monies you're owed. The court will then give you a review date. You'll need to be available by phone on that day, because a duty advisor, that's someone you can ask for free legal advice, will be on hand to answer your questions and talk to your landlord on your behalf. You can also ask them to set up mediation for you. That's a free service where a trained mediator, a trained professional, helps negotiate an agreement between you and your landlord. If you can't reach an agreement, the court will check the paperwork and give you a date for the possession hearing. Now, this is at least 4 weeks after the date you got the notice, but you can ask for more time. You're not guaranteed to get it. You can ask for more time by talking to your landlord or their solicitors. If you can't attend the court hearing in person, tell the court as soon as possible. They might, probably won't, but they might change the date or conduct it over a phone or a video call. It's important to prepare your case properly before your hearing. If you're more than 2 months behind with your monthly rent, or 8 weeks if it's weekly rent, the court has no choice but to issue a possession order. But if you can reduce your arrears below these thresholds, the court will decide whether it's reasonable to evict you. Whether or not you can pay back some of your arrears in time, you'll need to take evidence of your financial circumstances, such as wage slips and bank statements, of benefits you're waiting to be paid, of court paperwork, of rent or arrears receipts from your landlord, and an up-to-date household budget sheet showing your money in, your money out, and how much you have left to pay towards the rent arrears. At your possession hearing, you can speak on your own behalf, or you can get a lawyer to represent you. If you have a very low income, you might qualify for legal aid, but that's not common. Arrive early on the day so you have time to talk to the duty advisor. Your court documents will tell you how to contact the duty advisor. You're usually allowed to take someone with you for moral support, but check with the court first. The hearing lasts about 15 minutes. First, the judge will listen to your landlord, and then it's your or your advisor's turn. Address the judge as sir or madam, and be polite. Once the judge has considered your arguments and looked at the paperwork, they'll either dismiss the case, that's unlikely if you're in arrears, or they'll postpone the case, meaning the judge can't make a decision for some reason and the case gets put back to another date in the future, or they'll issue some sort of court order. The judge will only dismiss the case if there's no valid reason for evicting you. For example, if you've already paid off your debt. A serious error in your landlord's paperwork might also count as a valid reason to dismiss the case. Now, there are a few different types of court order that the court can make. An outright possession order means you'll be given a date by which to leave your home. This is usually within 2 to 4 weeks, but it could be extended to 6 weeks if you're able to show that you would suffer exceptional hardship, such as becoming homeless, if you're evicted sooner. A suspended possession order means that you'll have to meet some conditions, usually payment conditions, to stay in the property. Write down carefully what the judge says, because you won't receive a copy of the order for a few days at best, and possibly even a few weeks. Then there's a money order. That tells you how much you owe your landlord. If you don't pay, your landlord can send in bailiffs to seize your possessions or take money directly from your wages or your bank account. Any possession order might also include a money judgment. It will set out the amount you have to pay for arrears, for court fees, and your landlord's legal costs. In the case of a suspended possession order, this will only come into force if you don't keep up the payments. If you're at risk of homelessness, contact your local authority who can advise you on applying for social housing or emergency accommodation. If you found this video helpful, you might also be interested in this one, which covers the same issue from the landlord's perspective. And this one defines criminal harassment. I'm Barrister Daniel Barnett. Thank you so much for watching. Bye-bye.